Right from the opening, we're dealing with a high-stakes DUI trial and the defense is already swinging. The question hanging over the room was the officer's promise about going home if you blow under enough to influence the defendant's decision. Keep that in mind, it becomes the backbone of every argument that follows.
We are on the record in cause number 2505428, State of Texas versus Stephen Garcia. Today is February 11th, 2025. It's approximately 9:49 in the morning, a.m. Guys, I'd like you to please announce yourselves for purposes of the record. State first.
Diana Davila for the state of Texas.
Mackenzie Watson for the state of Texas.
Jim Butler for Stephen Garcia.
Okay, so I think that we were getting ahead of ourselves here. We started without even going on the record. So today is day for trial. Both parties have announced ready?
Yes,
This should.
Okay.
we're ready.
So what we have here is just kind of a brief introduction and where defense has challenged the breath test in this case and its admissibility thereof.
Pause here, notice how many times the officer allegedly repeated that promise. If someone in cuffs hears "you'll go home if you blow under," does that still feel like a choice or pressure? Let me know in the comments. Would you have relied on that statement too?
You guys have reviewed everything outside, correct?
Yeah, Judge, so just for the record, the state and the defense sat down in the back room and we kind of went through some of the motions. We went through the motion that I just filed. And then we also began going through the motions in limine. So, and then of course, we brought this motion to keep the breath test out, basically because the officer gave language that was outside the statutory language that they are supposed to give when they're offering somebody a breath test. And we're alleging that he basically tells my client, hey, look, if you blow, and if you blow under the legal limit, I'm going to put you in the car and take you home. And the evidence will show that my client relied upon that. In fact, at one point, when the officer is cuffing him and stuffing him, he's like, well, wait a minute, you said I was going to get to give a breath test, because he believed that he was under the limit, wasn't going to register, over 0.08, and was relying on the fact that if he gave that test, all of this ended and the officer would cut him loose and take him home. And then, of course, after that, and after the officer said, no, we got to go downtown because our machine's downtown, he again repeated that and said, look, if you blow under, we're going to get in the car and I'm going to take you home. And again, repeated that. And my client relied upon that and thought that that would happen. Of course, that's not what's going to happen. And Judge, and based on your experience, it's also possible that he could go down there and blow under the legal limit and the DA could still accept charges for DWI. So that was impermissible language that should not have been given in this case.
Response?
Here comes a major turning point. Both sides agree the facts occurred but argue over what they mean. The defense says the officer's words influenced consent. The state says consent still stands under case law. So what wins, the letter of the law or the impact of language? Think about which side you'd lean toward as you watch.
And one other thing,
And if
Judge.
you're not ready yet, it's okay, because I know that we're
Okay,
kind
I was
of,
just giving her the opportunity of what she wants to do. We did review the facts on the motion. We agree that the facts stated were as reflected on defense's motion. However, we do disagree with the case law given to support the fact that just because of the statements given by the officer, the breath test should be excluded. The underlying case law has negative treatment by the Texas Criminal Court of Appeals, and there is other cases within the same jurisdiction that have different treatment. However, we have come to the agreement that because what the case given by defense, once it goes upon appeal, it is only reviewed for abuse of discretion. And the case that overruled or gave negative treatment to Erdman says the same thing. Basically, it is the totality of the circumstances, and if you can if you're able to relate a certain link between what was specifically said to the officer and what the defendant believed to be true, and if that gave him a specific idea of what was going to happen or moved him towards the direction of the breath test versus the blood test. So I think we're both in agreement that the only way to resolve it is by you reviewing what was exactly said by the officer on the timestamp was given and using the court's discretion to come to the
Let
conclusion.
me ask you this. Have you had a chance to see whether Serrano, the case that he provided, I mean, it's right on point. Have you
It has not been
seen?
overruled, just so you know. And I think just to give you a little more information. So I agreed with that treatment of Erdman. I thought that it was not that great of a case because in Erdman, look, you had a officer that was doing nothing more than reading the statutory language. I mean, he wasn't even saying like, hey, go down there and give a sample. And if you are under, I'm going to take you home, which is like dangling candy in front of a baby, and that's the kind of thing that the law wants to prevent. The law says, here's the statute that you read. Navarro, which is another case that's cited among the cases that we're talking about.
I understand. Is there something that negates Serrano? Is there a case that says, hey, saying something like this is okay?
It would just be Finan, which is the Texas Criminal Appeals case that just states that it was not a breach of discretion to keep it out and that it would have to be a totality of the circumstances.
Okay.
And we 100% agree with that, and we know that. And so, Judge, the other thing that I wanted to say without going into Erdman is the Navarro case talks about, it's very good, and it talks about what the statutory language should be and why it is there and what it informs the person. If you give a test and if it's over the limit, here are the consequences of that. If you refuse the test, here are the consequences with your driver's license. And then, if you refuse, we can get a warrant to get your blood. That's all they're supposed to give them. And then they sit back and then the person either agrees or they don't agree. You can't sit there and then start enticing the person by telling them things to get them to change their mind. And clearly you're going to see that on the video. This officer says these extrajudicial statements. Hey, if we go down there, if you blow over or under, pardon me, we're going to get in the car and I'm going to take you home. Now, if you blow over, you're going to be arrested. But if you ask for a blood test, then you're also going to go to jail. And, it could be a week or however long before that blood comes back. So he's thinking, man, I better go down there and give a breath because I'm going to go home. And you just can't be saying stuff like that.
We have a panel here ready to go. So I don't want to keep them waiting. They've already been waiting for, 30 minutes. So how do you guys want to proceed?
If it's okay with you, I'm
Are
happy.
you ready to argue the merits of this? Because what I was going to suggest is that we go ahead, pick the jury, and then we can just start and finish argument with this.
Well,
Right after.
the only thing that
I don't want to keep them waiting.
No, I understand that. The only thing is that kind of does change the voir dire a bit, doesn't it?
If you want to exclude the breath test part of your voir dire, then I guess it can be talked about. It's not totally excluded, even if it gets excluded, because we can't force them into specific facts that there is no breath
Of
test.
course.
So I think
I guess we're ready to roll. But and then we can.
I just want to keep them waiting. Let's get it started, and then right after we get done with the paneling, then we can.
Sure.
And then that'll give you more time to look to see if there's something else that you want to look at as far as case law or whatnot.
And Judge, we'll print a copy for the court of the two outstanding case law that we have.
For sure. Okay. Good morning.
Good morning.
Thank you so very much for coming. You should really pat yourselves on the back. Really, I know that the weather's kind of crummy. I know that it's hot, humid, that most people don't want to be here. Look, I'd rather be at home too, but I really, your sense of civic duty, it's amazing. And I really, really thank you. And I love that we have such a great cross section of the community here today. that's what makes, criminal justice possible. A lot of other countries, a lot of other places don't have this. And that's what makes our system so great because, without you guys, we just can't function. My name is David Fleischer. I'm the judge here in County Criminal Court at Law Number 5. It is one of 16 misdemeanor courts here in Harris County. So just to give you a brief rundown, I don't know what you know, so I'm going to go from the top. So what are we? We are one of the misdemeanor courts. Well, what's a misdemeanor? Okay, well, in Texas, there are two types of offenses. There are felonies, and then there are misdemeanors. Does anybody know what the difference is? Anyone?
This is where procedure meets pressure. The defense wants the breath test tossed, the judge wants the jury moving. Strategy check: delaying arguments risks losing momentum, but pushing ahead means the case continues with the breath test still looming in the background. It's a courtroom balancing act, efficiency versus leverage.
So a year and above, you're looking at a felony in jail. And below that, a year and under, you're looking at a misdemeanor. Now, within those two categories, there's always subcategories just because of there's so many different types of crimes, they have to subcategorize it. I'm not going to get into the felony because we don't deal with that here. I like to sleep at night and those just, yeah. Anyways, so now within misdemeanors, there's three types. There's A, B, and C. Class C misdemeanor types are the type where, let's say you get pulled over for speeding, you get pulled over for no insurance, or, believe it or not, there's a Class C assault, disorderly conduct, whatever it may be. Depending on where you are in our city, because it's so big, you may go to municipal court, which a lot of people know about here on Lubbock. If you're out in Katy, you may go to a justice of the peace court. If you're out in Webster, or if you're out in that area, Clear Lake, you may go to one of the justice of the peace out there. So depending on where the occurrence happened is where you might go. Here in our criminal courts, our 16 county criminal courts, we deal with only B and A misdemeanors. B are punishable, anything punishable by up to 180 days and or a $2,000 fine. And Class A misdemeanors are those that are punishable by up to a year in jail and or a $4,000 fine. So we only have those two types that we deal with here in our county criminal court at law. Like I said, we have 16 of us because of the amount of people that we have here. And I will tell you now, percentage wise, I would say 7, maybe 8% of the people that are called upon to come for jury service actually show. It is such an abysmal rate that's why I really congratulate you on coming, because just we really sorely need more people to show up, because like I said, without you guys, we just can't function. So what we have here, we have two sets of lawyers that I'd like to introduce you to. We have the state's lawyers, and then we have defense. State, would you please identify yourselves? Does anybody recognize them? Okay, defense.
Good morning, I'm Jim Butler. Pleased to meet you all.
Does anybody recognize Mr. Butler? Okay, guys, please. So what we have now is we're here for a trial. I don't think that anybody disagrees with the law in general. What they disagree with is perhaps how things happened, whether someone is innocent, guilty, and that's why we have you here. We are really not asking you to split the atom. We're not asking you to do Pythagoras' theorem. All we are asking you to do is use common sense. What's going to happen is a fact pattern is going to be given to you guys. All we want you to do is listen and make a judgment call. I have told this time and again to all the jurors that come here. You really know when you listen to someone in your heart, in your gut, whether that person knows what they're talking about or whether they're from outer space. That's all we are asking you to do. Any kind of preconceived notions, any kind of past things, we're going to ask you, or they're going to ask you, whether you have something that has happened in your life that would render you unable to be able to sit for this type of case. Okay, we're here on a DWI. And so they're going to ask you whether there's something that has happened. But at the end of the day, all we want you to do is listen and make a judgment call, because you are the people that will listen, look at the evidence, and make a decision at the end of the day. So what we're going to do today is we will start with voir dire today, what we're doing, and then we will start with testimony tomorrow. And I anticipate that we will also conclude tomorrow. Is there anyone here that can't be here tomorrow? Anyone? Okay, you are 1, 2, 6. Okay. Is there anyone else that can't be here tomorrow for any reason? The last thing we want is we want you to get impaneled, and then for some reason you can't be here tomorrow. It's the worst. So that's why it's okay. We just want to know, is there something why you've got plane tickets, a doctor's appointment, one reason or the other that you can't be here tomorrow? Okay, so
Now we shift from legal argument to jury selection, but don't tune out. The defense knows the breath test ruling can swing the entire trial, so every juror seated might eventually hear evidence that shouldn't exist depending on how the judge rules. Here's the question: would you want to sit on a case where key evidence might disappear mid-trial?
now it's not just because you want to have lunch with someone. It's like, you got a serious doctor's appointment or, plane tickets, not just because you've got lunch with, So I got 5, 6, and 32. Is that it? Okay. Is there anyone here that is not comfortable with English? Doesn't speak English, speaks something different? Okay. And what number are you, ma'am? Okay. Anyone else? Okay. So what I'm going to do now is I'm going to turn it over to the lawyers. I'm going to give them each, about 25 minutes to speak to you, get to know you. I know it's a short amount of time to get to know someone, but the idea is that the only thing that we're looking for are people who really have an open mind and are fair. All literally just listen and then make a judgment call at the end. That's all we would like. Okay, are you ready? Okay, floor is yours.
I mean, most of us have our entire life seen this sign, right? Y'all remember seeing them blinking on the side of the road. Drink, drive, go to jail. But that is not the law. So the law actually in the state of Texas allows individuals to drink alcoholic beverages and drive as long as they're not intoxicated. Now, about myself, I love to go Loopy Tortillas. It's kind of like our treat on the weekend. Sometimes when we go there, you're waiting. The first thing that the waitress says when she comes up to the table is, "What? Can I get you something to drink?" And so I usually will have a margarita while we're waiting, and then we eat, and then during that I may have a beer. Does beer stink? Yes. Is it not the most disgusting odor? I mean, really, I sometimes wonder, even when I drink a beer, when did we ever decide, that this is good? It's so, so do you think that a person could be drinking a beer and driving home and then they get pulled over? What do you think they're going to smell like? Yeah. Hello, officer? Yeah. Right? What do you think that officer is going to think? Especially if it's early in the morning. Let's say they're coming home, they've been at their family's house or something, they've been hanging out, barbecuing. They're fine to drive, but they say, "Hello, officer." You think that officer is going to think that, something, I need to check this person out. You think that could happen? Yeah. What if you have not been stretching? I'm going to tell you something about myself y'all don't know. I've had 2 complete hip replacements. And then something, you wouldn't know it if I didn't tell you that, because I know I'm in such good shape. Y'all probably thought I was a gymnast. But I've had 2 complete hip replacements. How do you think that that would affect my ability if after coming home from Loopy's, I got asked to step out of the vehicle? First of all, if that happened, who thinks that they would be just swallowing their tongue? They'd be so nervous. Who thinks they'd be nervous? Anybody? You think you'd be nervous in that situation? I love it. My daughter, by the way, I'm going to brag a little bit. She used to be on the U.S. women's gymnastics team for 2 years. She got to represent the U.S. in Jesolo, Italy. And then, COVID broke out, and pretty much that was kind of unfortunate for her career after that because they weren't able to practice. But a gymnast practices their entire life on the beam, learning how to, and how many people have seen somebody walk on a beam in gymnastics? What do they use when they're walking? They use their arms, right? Why do we have arms? For balance. Would it be fair to ask somebody to walk like a lion and tell them, hey, but you can't use your arms for balance? Like if you wanted to design a test that made someone appear like they were off balance and kind of like clumsy, would you tell them, hey, walk like you normally walk? And by the way, walking that tightrope, you can use your arms? Or would you tell them, no, leave your arms down by your side? Which would you tell them?
Mr. Martinez, let me tell you, you scare me. It's individuals like you that just don't get it, how dangerous DWIs truly are, because you continue to do what you're doing, and you may truly have a problem. I hope that you don't dig yourself such a hole that you will never get out of. But that's what DWIs are. Invariably, if it continues, at some point, you may eventually kill someone. It's not fair. Don't. If you're going to drink, if you're going to get lit, if you're going to have 32 beers, stay the flip home. If you have to go out, take an Uber. Is it so hard? All you have to do is push one button on your phone and someone will take you home. With all the baggage that you have on your record now, if you ever get pulled over and an officer smells even one smidgen of alcohol, they're going to take you in. And from now on, you were looking at a felony offense of 2 to 10 in the penitentiary. So if you don't get it now, perhaps prison is what you need. You're young. You're going to be driving for the next 30 years. Get a clue. Do you understand?
Yes, Your Honor.
Yes, Your Honor.
The only reason I'm doing this now is because you're on probation for the next 2 years in another county. Otherwise, this would not be happening now. Take note and try to better yourself. It's not hard. All we're asking you to do is don't kill someone. Don't get into a car. You're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement. They're offering you 21 days in jail with credit for the 7 days that you've done. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this offense, it will go on your record. It's going to be there for the rest of your life. Somehow I have to get through to you. What I'm going to do to you now is you will be required to pay the DPS fines and fees of around $4,500. And if you don't pay it, every $100 you owe, you will sit 1 day in jail. Do you understand? I am also suspending your ability to drive for a year. Do not get into a car. If I see you back in here, it's really not going to go well.
No le va a ir
Do you
bien.
understand?
¿Usted lo entiende?
Yes, Judge.
I'm not asking for much. If you have a problem with alcohol, address it. That's all I'm asking to do. I'm literally, don't kill someone. How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
Is it true or untrue that you had a 0.15 or above? Okay, true to the enhancement. All right, Mr. Martinez, make us proud. That's all we're asking you to do. All right, let's see the clerk.
Thank you, Judge.
Thank you.
May I excuse me?
You are Jeffrey Atkins. Mr. Atkins, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Hey, good morning. This is Mr. Atkins, Atkins.
So on February 3rd, 2025, officers were dispatched for a theft. The witness stated he saw a black male steal a leaf blower from his driveway in Kingwood in Harris County, Texas, and place it in his vehicle's trunk. The suspect then got inside the back seat, and a traffic stop was initiated for the vehicle due to an on-view crime. The officer made commands for the individuals inside the vehicle to exit and lay on the ground until backup officers arrived. Both individuals were detained, and the defendant, the driver, was identified by Texas driver's license, and the officer located a firearm on the driver's side floorboard under the seat unholstered. The leaf blower was recovered from the trunk.
So we have a co-defendant.
So let me see. If there is a co-defendant in it. There is no other connected case, Your Honor.
No?
Yes.
Mr. Atkins, I'm going to find that there's probable cause to go forward with your case, sir. How old are you? I'm ordering you as a condition of your bond not to be in possession of weapons. You understand, sir? Did you want to apply for a court-appointed lawyer?
No.
Okay. Miranda's going to give you an application. I need you to fill it out for me. Do not, look at me. Do not pick up any new cases. Don't become a danger to my community. Otherwise, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand? No weapons. All right, come on. Do you mind filing that, please?
Yes.
All right. I'm going to have you go with Deputy Miranda. We'll have you sign a reset with Billy, and then I'll have you take a seat out there.
This is where the judge reminds jurors and us that common sense reigns. But keep listening. Jurors bring their whole life experiences into the courtroom, even when they try not to. So ask yourself, can anyone truly judge only the facts, or do personal beliefs and past experiences always sneak into the verdict?
Mr. Holt, this is your gentleman, huh?
Yes, Chicago. Could you give me just a moment?
Is he not here?
He is here.
Okay,
I just need a moment for doing something.
okay.
Go on.
Yeah, we need to do probable cause at some point, though.
Yes, sir.
Okay, just, I guess, let me know when you're ready. We're about to pick a jury, too, so just be ready.
It will take a second.
Okay, take your time. Yeah.
Any bond-
No, I guess, well, let's find out like a specific spot over there, since we're gonna have a jury coming in soon. Sure. You are Benny Boston. Mr. Boston, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 4th, 2025, at approximately 2:22 a.m., the officer observed a vehicle on East Sam Houston Parkway in the feeder road, failed to complete a stop at an intersection. A traffic stop was initiated, and the defendant, the driver and sole occupant of the vehicle, gave the officer his Texas driver's license. The officer found the driver's license to not be eligible, and the defendant had an active enforcement suspension for a DWLI that ends in April 23rd, 2025.
Mr. Boston, I'm going to find that there's probable cause to go forward with the case. I'm now having you sign an affidavit. This is a promise to me that you're going to make, that you're not going to drive today. I don't care what's going on in your life. If you want to drive, go get a license. get liability insurance, and then I will take this restriction off. But if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Sir.
Tell me, do you have the ability to hire lawyers, sir?
And then I think I get a court appointed.
Well, we just don't give them out like it's candy. You have to qualify. So what I can do is I can have you fill out an application. I'll take a look at it, but be honest on the application. I need to know everything about you and I'll see whether you qualify. All right. So Deputy Miranda is going to give an application. I'm going to have you come up here, swear to us that you're not going to drive, and then I'll have you sign a reset with Billy and then we'll get with you. Did you just get out of jail?
Yes, sir.
When? Okay. You didn't just get out of jail. When you come to court, come dressed appropriately. Shorts is not appropriate for court. It's a complete sign of disrespect. You understand? Okay. If you do it again, I'm going to put you out. You're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right?
Yes, Judge. On February 3rd, 2025, at approximately 11:53 p.m., the officer observed a vehicle on a public road with a defective front left headlamp, and the officer ran a check on the vehicle and it returned with unconfirmed insurance. A traffic stop was initiated, and the defendant quickly exited the vehicle, and the officer gave multiple commands for him to get back inside and shut the door. The defendant stated he wasn't going to, and the officer had no reason to pull him over. The defendant then walked back and got inside the vehicle, but held his feet outside the car and did not shut the door. From the officer's trained experience, he has seen situations where the driver sit like that, then leap from the car and try to hurt officers, and the defendant put his feet into the car and the officer approached. The vehicle had 2 young children, but not a car seat, standing in the front passenger seat, and the officer asked the defendant several times for his name, and the defendant stated he could not because the officer was fucking with him. The officer informed the defendant of the legitimate reason for the traffic stop, and the defendant continued to refuse to provide his name. The officer asked the defendant to exit the vehicle, and the defendant then refused. The officer went to grab the defendant's wrist, and the defendant pulled away from the officer and other deputies. The deputies advised the defendant that he was going to be tased, and the defendant exited the vehicle. The defendant stated he wasn't going in handcuffs and resisted by tensing his arms and body and concealing his hands towards his front waistband. The defendant was taken to the ground where he continued to resist. After several commands, the defendant was going to be tased. The defendant finally put his hands behind his back.
All right, Mr. Collier, I'm going to find that there's probable cause to go forward with your case. Can you run his license to see if he has a valid Texas driver license?
I'll run it right now, Your Honor. It's eligible, Your Honor.
Mr. Collier, I'm going to find that there's probable cause to go forward with your case. I'm not putting any conditions on your bond. Just be careful. You get into a pissing match with people who have the power of arrest. Who's going to win? You know what I mean?
Sir.
Just, it's a logical conclusion. That's all it is. Just be careful when you're out there. Life's hard enough. As an African-American in today's society, don't make it any harder, you know?
Sir.
You want to apply for an appointed lawyer?
Sir.
All right, I'm going to give you an application. I'll have you sign an reset with Billy. I'm not putting any conditions on your bond. Just be careful. That's it. All right? Come on, man.
Rory Johnson.
Hold on, Billy, because I think Mr. Holt is, are you ready?
Yes,
All right, come on. So you have Mr. Blanco.
Yes, Your Honor.
Hugo Blanco, come up. Good morning, Mr. Blanco. Sir, you're charged with terroristic threat on a public servant. That elevates it to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
It's Judge. On February 3rd, 2024, the officer was dispatched to Eastside Transportation and made contact with the complainant, a bus driver. The complainant explained that she made an exception to her usual route to drop off a student closer to home. When the complainant was halfway to the student's home, she opened the doors to let the student off, and the defendant approached the bus doors and appeared to grip an area where his firearm was located at his hip. The defendant asked the complainant if she planned to write up his daughter, and the complainant said yes. The defendant then took a few steps back and lifted his shirt to expose his firearm while making threatening statements. The complainant was in fear for her life and did not want to come back to work, and the officer confirmed the incident by bus camera footage. And specifically, the defendant lifted his shirt to expose his firearm while continuing to make threatening statements, telling the complainant, "I got you." And then seeing the firearm, the complainant quickly closed the bus doors to leave, and as they were closing, The defendant lifted his shirt again to display the firearm, still repeating, "I got you."
Mr. Blanco, I'm going to find that there's probable cause to go forward with the case. Look, I'm ordering you as a condition of your bond not to be in possession of weapons. Do you understand? As long as you can abide by these conditions, you and I will be fine. If I find that you pick up a new case, you have any kind of weapons, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Now you have a lawyer. Good job on having a lawyer. Because you have one, I will waive your appearance, but it is your responsibility to stay in touch with him, and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you're, ducking and dodging and playing games, I will issue a warrant for your arrest. I'm not asking much. I just want my public to be safe. You understand? All right. So I'm going to have you sign a receipt with Billy. We'll have you take a seat while we get your bond conditions. We'll have you sign it, and then you'll be free to go. All right. You found no weapons, please. And then no contact.
No contact.
Yeah, please. Mr. Holt,
Yes, sir.
I forgot to tell him no contact with the complaining witness. If you mind, please tell him.
Yes, sir.
Thanks.
Smith?
Hi.
Morning, Judge Mayor.
Yes, tell.
My name's Sabir Fareed. I'm just going to be covering until Deanna gets here. She's just running a few minutes late. I'm the chief in court 8 next door.
Okay, thanks.
Thank you so much.
We have a panel coming any minute, I think, so,
Sounds good.
yeah. Okay, thanks. Ready?
Rory Johnson, step up, please.
Coming up, Mr. Johnson, right here. Mr. Johnson, you were charged with evading arrest and detention. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge. On February 3rd, 2025, the officer observed a vehicle with no proof of financial responsibility. The officer also observed the registered owner of the vehicle to have an open warrant out of Harris County. The vehicle ran a red light and stopped past the designated stopping point, and the vehicle turned north, driving quickly as to elude the officer's patrol vehicle. The defendant pulled into a driveway. The defendant got out of the driver's seat as the officer attempted to initiate a traffic stop with emergency equipment for the traffic violations and conduct the investigation. The officer told the defendant to come to him, and the defendant began to evade on foot. The officer told the defendant to stop, but the defendant continued running, jumping over fences before he was taken into custody. The defendant evaded for approximately 100 to 200 yards and was identified based on his ID and name.
What was the basis of the stop again?
So no proof of financial responsibility and running a red light.
Got it. All right, Mr. Johnson, I'm going to find that there's probable cause to go forward with the case. I'm telling you now, you're extremely lucky that this is a misdemeanor. This is your third. On a second, it's a felony offense. You're very lucky. Can you run his license, please?
It's ineligible, not eligible, Your Honor.
Have you sign an affidavit with me today, Mr. Johnson? I don't care what's going on in your life. Do not drive. Do you understand? This is an affidavit that you're going to be promising me you're not going to drive. If you want to drive, go get a license, get liability insurance, and I will take this restriction off. But if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Do you have the ability to hire a lawyer, Mr. Johnson?
So,
I'll have you fill out an application. I'll take a look at it to see whether you qualify. I'm going to have you come up here, swear to us that you're not going to drive. I'm going to get you to Billy to sign a receipt, and then we'll take a look, fill it out. Don't pick up any new cases. Do you understand?
Sir.
You are lucky that this is not a felony offense right now as it is. So Mr. Montoya, you were charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 50 days in jail with credit for the 50 days that you've done.
Yes.
Oh, he has another DWI. Did you see that?
Well, there's a question whether it's in.
So Freestone County has a hold on this gentleman for a DWI above a 0.15
Está conocido por más
He
de
doesn't
0.5.
acknowledge that, Judge.
Él no reconoce. Eso sucedió
is a prior DWI from the same place,
en un lugar.
you need to realize something,
Necesita que tomar en cuenta
Mr. Montoya, that
que
this now may very well be your second DWI conviction because you're pleading guilty to this DWI. Once you have two DWIs, when you pick up a third, you're looking at a third-degree felony, 2 to 10 in the penitentiary. Is that what it's going to take? Prison time? Some people only learn the hard way.
en la penitencia dicen, hay unas personas que
Is that is what it's going to take? Watch the news. Every single day in our county here, someone dies from a DWI when it is extremely easy. One button on a phone,
un botón muy
an Uber will take you wherever you need to go for $30 freaking dollars.
$40.
From now on, you may be very well facing up to 10 years in prison, even with a sip of alcohol because of your record.
Por su expediente
You give
criminal.
up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record. It will be there for the rest of your natural-born life.
Hasta todo su vida.
Do you understand?
¿Lo entiende? Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Culpable o no culpable. Guilty.
Don't kill anyone. That's all we're asking. Don't kill anyone. We have enough death on the streets as it is. You have a DWI here, you have another one open somewhere else. You have one from last year. What's it going to take?
Uno del año pasado.
I'm suspending your license. Is this pled as a first or is it pled as a second? I'm suspending your license for a year. Do not drive. Stop driving.
Deja de manejar.
Flood is his first investigation.
I'm not asking for much, man. Really.
Verdad.
Good luck to you, man.
Suerte,
He's
sí.
got nice old birds.
Tiene presión migratoria.
He still has another DWI in another county, man. Really. Hi.
Yeah, good morning. Raquel Williams. It's a DWI. We just need to get medical records released. They're gonna file the motion. I just wanted to approach to see if we can make note of it. It can be done in between time instead of when we come back for that release.
You mean,
There's,
have medical records ready to give to them?
Yes, and we just need to file the motion.
Okay, so go ahead, file it. I'll sign it. As soon as you file it, I'll sign it. So it's old though. It's 184 days old. Do you have an offer?
we're supposed to be trying to get PTI on it. She did a TRAS, the last.
So first apply. Don't just get the TRAS because, there's a lot of changes that have been made. So I've seen more denials now. So,
She's already done the TRAS.
oh, she's already done it.
Yeah, I had her do it when she was here last time because her appearance had been waived, so
Tell me, is breath test?
it should be blood from, it was a hospital visit, so, yeah, there was blood. It was like a point one.
What is it? What are the results?
7, I believe.
Don't.
It's a 0.17.
I'm curious to see whether she's approved or if she needs a medication packet.
It was 10125.
What is it?
125.
Okay, okay, so it's not.
I did have, mitigation. I need to scan everything and send it over. I got, it
Accident?
was an accident.
So the-
She ran into the back of a tow vehicle,
I think that you're
but still an accident.
still gonna need it.
Right.
Like this, they're gonna want insurance and all that stuff.
Right.
How much time do you want?
I can't hear you, Judge.
Shh. How much time do you want?
I don't, a couple weeks is fine with me. I don't need.
So
I'll be
what I
able
would,
to-
so can you get the records to her today? Please file the motion. I'll sign it now. That way we're ready with that. And then in the interim, we'll give you 2 to 3 weeks.
Okay.
But the next setting, if you can have everything turned in, and then that way we'll wait for a response, whether approved or denied. And I mean,
And then I have a question for you, Judge. Her license is valid now. Is can she drive? She wanted me to ask for permission. Last time you told her to ask before doing anything. She's working, but Dad is taking her back and
I would
forth.
ask is just make sure that she has liability insurance, right? Make sure she has car insurance. If she has car insurance, then I'm okay
Dad
with
told
it.
me he
As
put
long
her
as the
on.
license is clear and she has insurance, I'm okay with it.
Just want to document it. It's fine.
Alicia, on Raquel Williams, we ordered no driving. Can you confirm with her now? Ms. Moore, can you confirm with her now? Does she have insurance now?
Dad will
Car
place her on. I confirmed with him. He was here last setting with her, and they were ready to confirm it then.
So they have car insurance?
It's not. Let me find out if he actually, because I told him that last time. Judge is going to want to know you have it already.
As long as she has car insurance, I'll amend the conditions to allow her to drive.
Okay. Okay.
Yeah. And then after that, if she does, let Felicia know, and then we'll amend the conditions to allow her to drive, and then just get a reset with Billy, and then, yeah. Mr. Butler, are you able to work it out or no?
Work out some of the.
Just the case in general or no?
So they agree that my issue is, good and valid on that first case. And we can talk about it if you want to.
No, I get it.
Yes, sir. And we've had to show you from the years.